Okay, let's unpack this. Welcome to a deep dive focused squarely on one specific corner of the business world in Bahrain, general partnership companies. We're going straight to the source today, pulling insights directly from Legislative Decree No. 21 of 2001, specifically Part 2, which lays out the fundamental rules. Our mission is to cut through the legal text and extract the absolute must-know information. We want to get a clear picture of how these companies are structured, what's required to get one off the ground, the core responsibilities of the partners, and perhaps most importantly, what kind of personal risk is involved. This deep dive is tailored specifically for you, listener. Whether you're exploring business structures, need to understand this entity for work, or are just plain curious, we're here to help you become well-informed quickly.
And what's fascinating here is that we're looking at a legal framework designed for a very specific, often deeply personal kind of business relationship. Understanding these foundational rules from the law itself is absolutely essential because, well, they define everything about this structure.
So let's start at the very beginning. What is a general partnership according to this law? Article 25 tells us it's formed between two or more individuals operating under a specific name. Pretty standard so far, right?
Right. But the defining characteristic, the absolute core that sets it apart, is in the very next part of Article 25. It states that the partners assume joint responsibility for the company's obligations, extending to the full extent of all their personal funds.
Wow.
This is the big one.
Yeah.
Unlimited personal liability for every single partner. The law also mentions that both Bahraini and non-Bahraini partners are allowed. Those specific conditions might apply depending on regulations set by the relevant ministry.
Okay, whoa. Joint responsibility extending to all their funds. That's a massive nugget right there. So if you're looking at this structure, the first thing you absolutely must grasp is the personal risk. Now, if you accept that risk and decide this is the path, how do you actually set one up? What absolutely has to be in that foundational document, the Memorandum of Association, or MOA?
Well, Article 26 gives us a really detailed list of what this MOA must contain. Think of it as the company's constitution, really. You need things like the company's name and its official address where its head office is located. You also need to clearly state the company's purpose, its objects. Then you have to list all the partners, their full names, nationalities, and where they live or are legally based, their domiciles.
And it doesn't stop there, does it?
No, no. You need to name the managers who are authorized to run things and sign on behalf of the company, they could be partners or not, and clearly state their specific powers. The MOA also has to detail the company's total capital, how much each partner is contributing, and crucially, how any profits or losses will be shared among the partners. Plus, you'll need to specify if the company has a fixed term, when its financial year starts and ends, and even outline the method for liquidating the company and dividing assets if it ever dissolves.
That's a really comprehensive list of required information right at the outset. It feels like the law wants everything about the core structure and who's involved laid bare from day one.
Precisely. That level of detail is required for legal identity and transparency. And once that comprehensive MOA is ready, Article 30 mandates two critical legal steps. It has to be formally entered into the commercial registry, following their rules, and a summary of that MOA must be published publicly in the official gazette, and the company actually pays for that publication.
So getting it registered and making it public are non-negotiable steps. And Article 31 is quite specific about what must be included in that public summary in the Gazette, right?
Yes, the summary needs to cover the essentials. The company name, its purpose, the head office location. It must list the partners by name, domicile, occupation, and nationality. It needs to state the company's capital and give enough detail about the partners' contributions and when they're due. Crucially, it lists the names of the managers and anyone authorized to sign on behalf of the company, the date the company was formed, its duration if it's limited, and the start and end of the financial year. If we connect this to the bigger picture, this public notification ensures that anyone dealing with the company can access key information about its structure and, who is responsible.
Speaking of names, Article 27 has specific rules about what the company name can be. You can't just call it anything you like.
Exactly. The law dictates that the name has to include the names of all the partners, or at least the name of one partner, followed by something like ENCO to show it's a partnership. An amendment in 2018 added that another name acceptable to the relevant ministry is also possible. And importantly, the name must always finish with a Bahraini partnership company. It also has to reflect the company's current status, meaning you can't keep using the name of someone who is no longer a partner.
And Article 28 lays down a pretty serious consequence if you include a non-partner's name in the company name.
It does. If someone who isn't a partner has their name included in the company name, and crucially they know about it, they can become jointly liable for the company's debts. This liability applies towards any third party who, acting in good faith, relied on that name believing that person was a partner.
Interesting. So that raises an important question. What does in good faith mean here for that third party?
Generally, it means they genuinely believe the person was a partner based on the name and didn't have any reason to suspect otherwise. It's about their reasonable belief.
Okay. So the MOA is the mandatory public document, but Article 29 mentions that partners can also create something called Articles of Incorporation. What are those for?
Right. Think of the MOA as the company's external foundational constitution. It's legally required and public. The Articles of Incorporation, mentioned in Article 29, are different. They are optional internal documents. They are for the detailed provisions the partners agree upon for the internal administration and running of the company. Day-to-day stuff, internal rules. They must be a notarized written instrument and attached to the MOA.
Ah, okay. So MOA is the high-level public charter, and Articles of Incorporation are where you put all the detailed rules for how you'll operate internally.
Precisely. The MOA sets the stage and key legal facts, while the Articles of Incorporation allow partners to add more specific internal operational details if they choose to.
Now, here's where it gets really interesting and ties back directly to that unlimited personal liability we mentioned earlier. Article 32 states that each partner is considered a trader or merchant and is treated as conducting business under the company's name. And here's the absolute critical nugget from this article. The bankruptcy of the company automatically means the bankruptcy of all the partners personally.
That is intense.
Yeah.
It truly is. So if the company goes down, every partner's personal finances are potentially wiped out too.
Wow.
Exactly. It underscores just how intertwined the partners are with the business financially. And Article 35 expands on this, detailing just how far creditors can reach. Company creditors can go after the company's assets, sure, but they also have the right to pursue the private property of any partner who was a partner when the debt was incurred. All partners are jointly liable for these debts, meaning a creditor could potentially go after just one partner for the whole amount if that partner has the assets available.
Jointly liable.
And pay attention here. Any agreement the partners make among themselves, maybe in the MOA or articles, to limit their liability against external creditors is totally invalid against those third parties. You simply cannot shield your personal assets from company creditors in this structure, no matter what internal agreement you have.
Wow. So the joint and unlimited liability isn't just a legal phrase. It has real, potentially devastating personal financial consequences. What about partners joining or leaving? How does that impact their liability for existing or future debts?
Right. Article 36 addresses this crucial point, and here's a key nugget for new partners. If someone joins an existing general partnership, they become jointly liable with the existing partners. Again, with all their personal property, for the company's debts incurred before they joined, as well as those incurred after they joined.
Before they even join.
Yes. And again, any internal agreement saying they're only liable for future debts is useless against outside creditors. They inherit the past.
Okay, so joining means you inherit all past debts, even if you have nothing to do with them. That's a huge risk for incoming partners to consider.
It is. It's significant. Now, if a partner withdraws from the company, they are not liable for liabilities that arise after the publication of their withdrawal in the official gazette. Publication is absolutely key here for stopping future liability.
Got it. Publication stops future risk.
But if a partner assigns their shares to someone else, maybe sells their stake, they are not discharged from their liability for the company's existing obligations to creditors unless those specific creditors actually approve the assignment.
So just selling your share doesn't get you off the hook for old debts automatically.
Not unless the creditors agree. It makes sense they extended credit based on the partners at the time.
So joining makes you liable for past and future debts. Withdrawing and publishing stops future liability. But assigning your share doesn't automatically relieve you of responsibility for the debts that existed while you were a partner. Got it.
And while creditors can come after a partner's private property, Article 37 provides a procedural layer. A creditor can't just, immediately seize a partner's personal assets. Execution against a partner's property for company debts can only happen after they've obtained a court judgment against the company itself and served a formal notice on the company demanding the liabilities be paid. The judgment against the company then serves as valid proof against the partner in the subsequent action against their personal property. It's a two-step process.
Okay, so there's a legal process, a buffer, but the underlying personal exposure is definitely there and it's significant. What about how partners behave within the business? Can a partner easily sell their stake or share? Article 33 says partner shares can't be represented by negotiable instruments like stocks or bonds, which you can easily trade.
Right, and this reflects the personal nature of the partnership. It's built on trust between specific individuals. So, a partner generally cannot transfer or assign their share to a third party without the unanimous consent of all the other partners. Everyone has to agree.
Unanimous consent.
Yes. Now, the MOA can specify conditions that allow assignment otherwise, maybe with a supermajority or something. But the law explicitly states that any agreement in the MOA that permits assigning shares without any restrictions whatsoever is null and void. The law wants there to be some control over who becomes a partner, given that unlimited liability aspect we keep coming back to.
That makes total sense. Since you're personally on the hook for what the others do, you absolutely need to have a say in who those partners are.
Exactly. It's all about that inherent trust requirement.
Mhm.
And Article 34 makes a related clarification. Just because an employee shares in the profits, maybe instead of taking a fixed wage, does not automatically make them a partner with unlimited liability. This is important for companies using profit-sharing incentives.
Good distinction. Now, another major restriction is covered in Article 38. Partners are generally prohibited from starting a competing business or being partners in another competing company, right? Like another general partnership, limited partnership, or even an LLC if it's competing directly. This prevents conflicts of interest.
Absolutely. And what happens if a partner breaches this rule and competes anyway?
Yeah, what's the consequence?
The partnership has options, and they're quite powerful. They can sue the partner for compensation for the damages caused by the competition. Pretty standard. Or, and this is where it gets really interesting, they can choose to treat the competing activity the partner did for themselves as actually having been done for the partnership's account.
Oh, wow.
If they choose this, the partner is forced to hand over all the profits they made from that competing business to the partnership. And they can't try to offset those profits against any profits they were already entitled to from the main partnership.
Ouch. That sounds like a very effective deterrent against partners competing with their own company.
It certainly seems designed that way.
And Article 39 deals with how partners handle company money or use their own money for the company.
It sets the financial boundaries, basically. If a partner takes or keeps company funds without authorization, they must pay it back, usually with compensation for the company's loss or delay. Conversely, if a partner uses their own money for the company's benefit, acting in good faith, the company is required to reimburse them, often with compensation reflecting the benefit the company gained from that expenditure. It creates clear financial obligations and rights between partners and the company's resources.
Okay, let's shift gears slightly to who actually manages the business day to day. Article 40 allows for flexibility here, doesn't it?
It does. Management can be handled by all the partners acting together or by one or more appointed managers. And these managers can be partners or individuals who aren't partners at all, and they can be appointed either in the MOA itself or in a separate contract later on.
Okay, so options there. But the law then gets quite detailed about how multiple managers operate. What does Article 41 say?
Article 41 covers the scenario where you have multiple managers, but their specific powers aren't clearly defined, and none have exclusive authority. Maybe the MOA just lists names. In this case, each manager can act individually, but any other manager has the right to object to the action before it's completed. If there's an objection, the majority opinion among the managers decides the issue. If they're tied, the matter goes to all the partners for resolution.
So individual action is allowed but checked by other managers, with partners as the ultimate tiebreaker. What if the MOA requires them to manage jointly?
Article 42 addresses joint management. Here, decisions generally require unanimity among the managers, unless the MOA explicitly permits a specific majority threshold, like 2/3 or something. The only time this unanimity rule can be overridden is in an urgent situation and exigency, where delaying the decision would cause significant loss or missed profit for the company. Only for emergencies, basically.
And what's the default if the MOA doesn't say anything about management at all? Just silent on the issue?
If the MOA is silent on management, Article 43 states that every single partner is considered authorized to manage the company, even without consulting the others.
Every partner. Wow.
Yes, but just like the individual manager scenario, any other partner can object to an action before it's completed. In this specific default situation, though, It's the majority of partners who have the power to reject that objection, not just a majority of managers. The power rests with the partners overall.
That's a different dynamic again, giving oversight power directly to the majority of partners if management isn't explicitly structured. What about partners who aren't involved in the day-to-day management? What rights do they have?
Article 46 is important for non-managing partners. While they can't interfere in the active management, they can't tell managers what to do. The law gives them essential oversight rights, and these rights cannot be taken away, even by agreement in the MOA.
Cannot be taken away. Like what?
They have the right to inspect the company's books and documents, personally or through an agent. They can visit the head office to check on affairs, get summaries of the financial situation from the managers, and offer advice to the managers. Any clause in the MOA trying to prevent these rights is null and void.
That provides a crucial check and balance authority for the managers, but transparency and oversight rights guaranteed for all partners. And Article 47 is interesting regarding the company's liability for manager actions.
Yes. It states the company is bound by actions a manager takes within their scope of authority and function, as long as they use the company's commercial name when doing it. This is binding on the company even if the manager was actually acting for their own personal benefit, provided the third party they were dealing with was acting in good faith.
Good faith again.
Exactly. The key elements are the use of the company name and the third party's good faith belief they were dealing legitimately with the company through its authorized manager.
Now, here's a really significant practical point that affects the stability of the business. Can a manager be removed or can they just quit? Articles 44 and 45 create a big distinction based on how the manager was appointed. This seems critical.
It is. This distinction is one of the most impactful nuggets from this section, I think. Okay, scenario 1. If a manager is a partner and was appointed specifically by being named in the Memorandum of Association in that foundational document, their position is very secure. They can only be removed by a court judgment. This judgment must be requested by the majority of partners and requires a justifiable reason. You need a good cause approved by a court.
Only by court judgment.
Only by court judgment. Any agreement in the MOA trying to allow removal without a court judgment or without a just cause is null. And critically, if a partner manager appointed in the MOA is removed this way, it dissolves the entire company, unless the MOA specifically states the company continues with the remaining partners.
Dissolves the company, just by removing one manager.
If they were a partner appointed in the MOA, yes. Similarly, such a manager cannot resign for an unacceptable reason or at an inopportune time. If they do, they can be liable for compensation. And their resignation also dissolves the company unless the MOA provides for continuity.
Wow, that is a huge consequence. Being named manager in the founding document ties that partner's role directly to the company's very existence. It really emphasizes the deeply personal nature of these partnerships.
Absolutely. It shows how integral that specific person, named to the MOA, is considered to the original deal. Now compare that to other manager types covered in Article 45. If the manager is a partner appointed by a separate contract, so not named in the MOA, or if the manager is not a partner at all, whether they were appointed in the MOA or separately.
Yes. How does that work?
Their removal is much simpler. They can be removed by a resolution passed by a majority of the partners. No court needed. And importantly, this removal does not dissolve the company.
Ah, okay. Big difference.
Huge difference. They can also resign, but they should do so at an opportune time and provide reasonable notice. Otherwise, they might be liable for compensation if it harms the company. But again, their resignation in these cases does not dissolve the company.
That is a massive difference in terms of business continuity. It really highlights the strategic importance of how managers are appointed, especially if they are partners, whether it's in the MOA itself or through a separate agreement.
Definitely. It's a major structuring decision with long-term implications. And it's worth noting that the appointment or removal of any manager, regardless of how they were appointed, must be registered in the commercial registry and published in the official gazette. This ensures public awareness of who currently holds the authority to act for the company.
Right, keeping that public record up to date. Finally, let's touch on general decision-making beyond day-to-day management and how profits are shared. Article 48 outlines resolutions on company matters. How are those decisions made?
Generally, decisions for the company that aren't purely management tasks delegated to managers require the unanimous vote of all partners. That's the default. However, the MOA can specify a majority voting rule for certain matters if the partners agree to that up front.
Okay, so unanimity is the default, but The MOA can allow majority voting for some things. Is there anything that always requires unanimity? No exceptions.
Yes, and this really reinforces the primacy of the MOA. Article 48 explicitly states that resolutions to amend the Memorandum of Association itself are never valid unless they are adopted by the unanimity of all partners' votes.
Never valid without unanimity.
Correct. You can't change the company's core constitution, that foundational document, without every single partner agreeing.
Makes sense. And Article 49 deals with how profits and losses are actually handled.
Yes. These are determined annually after preparing the balance sheet and the profit and loss statement for the financial year. Once the balance sheet is approved by the partners, or whoever has authority to approve it, a partner's share of the profits officially becomes a debt the company owes them. They have a right to claim it.
And what about losses? How are they covered?
If the company has losses that reduce its capital, those shortages are typically covered by profits from future years, unless the partners agree on a different approach in the MOA or elsewhere. But here's another key point about capital. A partner generally cannot be forced to cover a capital shortage directly from their initial capital contribution shares without their specific consent.
So they're liable with their personal assets, but their original investment stake is somewhat protected from automatic top-ups for losses.
Generally, yes. They are liable with all their other personal funds because of the unlimited liability, but the law provides some protection for the initial capital stake itself from being automatically tapped to cover ongoing operational losses, unless the partner agrees to replenish it.
Wow, okay. That was a real deep dive straight into the source material, Legislative Decree number 21 of 2001, covering the specifics of Bahraini general partnerships. We've unpacked everything from the foundational documents and the rules around the company name, through the intense reality of joint and unlimited partner liability, the complexities of management appointments and removals, and finally, how decisions are made and financials are handled. It's a lot to take in.
It is, and we've seen clearly that this structure is really built on the personal involvement and, frankly, the significant financial exposure of the partners. That's the defining feature. The law provides a detailed default framework, but it also gives partners strategic flexibility through that Memorandum of Association, particularly regarding things like management structures, decision-making thresholds, and maybe how partner shares can be transferred, although, as we saw, some things like changing the MOA itself always require unanimity.
Right. Understanding these nuances, especially that critical distinction in manager removal consequences depending on how they were appointed, and the full scope of personal liability, seems absolutely fundamental. It's key to grasping the practical implications of operating within or even dealing with this type of entity.
Absolutely. You need to know what you're getting into.
So what does all this mean for you, the listener? If you're exploring setting up a business in Bahrain or interacting with a general partnership there, the key takeaways really are the critical nature of that personal, unlimited liability for all partners, and the immense importance of carefully drafting that initial Memorandum of Association. It's not just paperwork. It sets fundamental rules that are difficult to change and can, as we saw, impact the company's very existence depending on how managers are appointed.
It shapes the entire relationship and risk profile.
So, as you think about everything we've covered today, here's a thought for you to mull over. Considering the law makes removing a partner manager named in the MOA so difficult, often requiring court action and potentially dissolving the entire company, what strategies might partners consider at the formation stage? How could they build in mechanisms for potentially smoother, less disruptive leadership transitions if a key partner, named in the MOA, needs to step away from management down the line while still fully respecting this legal framework? It seems like a real planning challenge, something to explore. Thanks for joining us for this deep dive.
Until next time.